Welcome back, Honorable Commissioners. Welcome, Judge Marete, to this interview. I think there'll be a session of photographs, and then we'll start the session, Your Honor. So please, 1 minute for the photographers. Thank you very much, Your Honor. Once again, welcome to this session. This session, Your Honor, will be a bit shorter because we had a long discussion with you about 2 weeks ago. And the commissioners will determine what to focus on, maybe more on the jurisprudence and other legal matters. We will introduce ourselves once again to you, Your Honor, and I will start with our acting CJ. The technical people, we need the microphones to work. AG is just working. We can start from your side, and then we'll come round as they fix that one. Frida.
Thank you, Madam Chair. Good morning, Judge. Kahara Kariuki, the Attorney General.
Morning, my Lord.
Morning, sir.
Mohamed Warsame, welcome once again, my Lord.
It's a big pleasure all the time.
Good morning, Judge.
Good morning, sir.
My name is Felix Koske, representing the public. Welcome.
We thank you.
Good morning, my Lord. My name is Machari Njagi. I represent the Law Society of Kenya.
It's a big pleasure, good Commissioner.
Good morning, my Lord.
Good morning.
I am still Philomena Mbeteni. I represent the Supreme Court here. I'm the Deputy Chief Justice of the Republic of Kenya.
We thank you.
Good morning, Judge.
Good morning, sir.
I'm Patrick Shoi. I represent public service. Karibu.
Asante.
Good morning. David Majanja, Judge of the High Court, representing Kenya Magistrates and Judges Association.
A big pleasure, sir.
Good morning, my Lord.
Good morning.
I'm Olwande Evelyn, Chief Magistrate, representing KMJ.
We thank you.
My Lord, I'm Olive Mugenda, Commissioner representing the public and chairing these interviews. And we also are supported by our CRJ, Honorable Anne Amadi.
Good
morning, Judge.
Good morning.
And also by the Registrar of Judiciary of JSC, Honorable Frida Mukaya.
A big pleasure to you all.
So, Judge, will start with the interviews now, but I have one observation to make. The fact that you have received the letter where you have submitted the documents that were missing last time. The wealth declaration, now you have completed it, and the bank statement. Your Honor, I also noted that we have now a new copy of the disability card, which, as you said, it was an error and it has been corrected. So I just wanted to make that observation. And I don't know whether you have the original or we go by this copy.
I do have the original. It is available with me.
Thank you very much, Judge. So those forms are now with us, and we want to thank you for that effort.
Thank you.
So I'll start off by asking one question, Honorable Judge. If you join the Supreme Court, where there will be other colleagues, working with you, and so far, Your Honor, you have been your own boss, making your own decisions and have, enjoying your independence. So please give us 3 differentiating attributes that you are going to take to that court. Because we all have our own strengths. What is this that is unique, Honorable Judge, that you are going to take to that Supreme Court?
To the Supreme Court, I'll bring in collegiality in a personal manner. I am a peacemaker. I am able to deal with public relations so finely. I make peace with everybody and anybody. That is what I would take to the Supreme Court. Firstly, to enhance collegiality, to enhance team spirit, to enhance what we may require in the Supreme Court to be able to be effective and play our role, our constitutional role as stipulated. The second one, which I would take there, is my exposure and experience from day one and 16th of October 1980 to date. Well over 40 years. We've been in this game, the game of the law, and we've learned the ropes. So you will not be able to say that, or we cannot say that because you've been your own boss, etc., you are not superb or fit for this kind of a position. When you have the know-how, when you have the exposure, we've been to the House of Lords, we've been everywhere in the common law and the Commonwealth. We've been in Kenya, we've done East Africa. We are familiar with this game, and there's nothing which would make us any poorer in dealing with the issue. We also have our own good attributes. Like I said last time, I'm a superb leader. It is demonstrated all over my life. I gave, notable examples of my leadership capacity. I've not been working alone, and it is not possible to work alone. So this is what we would carry to the Supreme Court to enhance its efficacy in constitutionalism. Thank you.
Thank you, Judge, for that answer. Your Honor, there's some theories that suggest that for you to get to achieve your deliverables or your goals, that you need maybe 70-80% emotional intelligence and maybe 30%, 20% of IQ. Do you believe in this view?
So much so. It is the rule of the world. It is a universal truism that so much is not done on by virtue of your strength or intelligence. Those are just side issues. What you require is the element of a relationship that carries the better part of your projections, the better part of your achievements, etc. We are saying this because you may have everything that you may require in terms of IQ, etc. But this is not going to work for you if you don't have the wherewithal of emotional intelligence. If you cannot relate, if you cannot be able to differentiate what is workable and what is not workable, if you are not able to deal with everybody with a view to achieving any collective results, that way your brain, your intellectuality, your all becomes not very useful to humankind. Therefore, this is a daily practice. something you must keep on learning to do every day of your life so that you become useful. Minus that, you'll be on your own and you won't make any contribution whatsoever to anybody. Thank you.
Thank you, Your Honor. My last question, Your Honor, is in every group, even in the Supreme Court where you go, there will be the leader. I mean, your leader will be the president of the Supreme Court. But also in all the groups, there emerges other leaders who are not there because, by virtue of their positions, but they're just natural leaders in that group. So my question to you, Judge, is that do you see yourselves emerging as another leader, maybe in an area where you're very strong in, or are you just going to, to follow what your boss says? And if you're going to emerge as another leader, which area do you think you can come out strongly as a leader, despite the fact that you'll be having your president in the same court?
Thank you, Chair. I'll clearly and undoubtedly emerge as a leader because this has been demonstrated. Organizational skills is my hallmark. Last time we were here, I told you that I'm a very organized person. I am a very timeous person. I get things done and on the dot. This may be boring to many other people. You don't necessarily have to get them into it by force, but you can buy them into it. You can teach them the game. So organizational skills, industry are my hallmarks. And this is demonstrated all over from day 1 to 61 years and 4 months. That is what I'm going to sell to the Supreme Court of Kenya. I'm not confrontational. We shall have our natural leader, the President of the Supreme Court of Kenya, the Deputy President of the Supreme Court of Kenya, and the other group of 7, and it is proposed 9, maybe in the future, will come up with a different leadership quotients and serve the court, and serve Kenya, and serve humankind. Thank you.
Thank you very much, Your Honor. I will now request Acting CJ to continue with the questions.
Thank you. My Lord, let us start at the point of amicus curiae and interested parties. If my Lord would please tell us how the court, my Lord, wishes to join, has handled those 2 issues.
Traditionally, good acting CJ and Commissioner, amicus curiae was a friend of the court. That is a customary position. This has developed with time, and it has even gotten very complex in the sense that we have had to develop other avenues in which to accommodate amicus curiae. In interested party, the differential between amicus curiae and the interested party is that the interested party has a direct interest in the matter which is being heard. Let me go back to amicus curiae. What has changed of late is that we found the situations, and we will be forced to address these situations in the future, where people do not necessarily come to courts as amicus curiae to pursue that unilateral, that area where they are just friends of the court and impartial. We've noted more often than not that these people may come on that note, but in the course of time, they become even parties to the suit. So we may have to, in the future, develop strategies of dealing with that, because where, like is in the international foreign practice, we even have amicus curiae who may have some interest in the matter. amicus curiae who clearly do not have any interest in the matter. The categorization of amicus curiae must now be developed in this in our jurisdiction, so that we are able to manage that in an effective manner without hiding faces or playing behind. Interested?
No. Let's stay with the amicus curiae first.
Yes.
And the question, my lord, is to tell us what the court, what your dream court has already done, because it has, in a number of cases, defined the status of the amicus curiae and how one is to approach the court.
The court has set out a precedent to the extent which amicus curiae would come out. This is by bringing a 6-point amicus curiae forum. And this is what I was referring to, like moving from the traditional amicus curiae, where you are merely a friend of the court. We brought out issues where people who have some interest of whatever nature may come in as amicus curiae. We brought in areas where people who have no interest whatsoever may come in as amicus curiae. We brought up other issues where we brought in a situation where other parties who have tangible issues on that subject matter may want to come in as amicus curiae. We may have other situations where groups or interested parties may want to come in as not as individuals but as a group to raise issues which add on to the subject matter and assist in its formulation. Those are the few examples I can remember.
Okay.
There are quite a number.
Okay. Does my lord remember any Supreme Court case that has specifically dealt with the amicus curiae?
I have read this generally. I cannot specifically
Thank
point
you, my
out
lord.
any authority.
Is there a distinction between, my lord, the amicus curiae and interested party?
The distinction is very, very clear. In interested party, this person has a direct or even indirect interest in the matter. The outcome of the matter will directly involve him, or directly or indirectly involve him. So he's not coming in, he's not even borrowing from the traditional amicus curiae where you are a friend of the court. He's coming in to pursue his interests, which may be direct or indirect. That is the difference.
Any case that comes to mind, my lord, by the Supreme Court on...
Again, on that one, I falter.
Thank you, my lord.
Please.
You would say, or would you not, that the Supreme Court is not busy, would you?
No, the Supreme Court is very, very busy.
Good.
Very busy to the extent that it is even backlogged, which is very, very unfortunate. That's a place, if you ask me, where we should be free of a backlog. And I'll be dealing with matters within a month, 2 or 3, when that is practical and possible. The Supreme Court is busy to answer your question.
Do you know, my lord, the extent of that so-called backlog?
It is about 200 and, did I read 235 cases? It's between 100 and 250 cases, if I read right.
My lord, that are backlog in the Supreme Court? Let's stay there. And please, my lord, tell us what in
that
your
could be
view-
the number of due cases. Please ask your question.
I already asked part 1, but let me ask part 2. Whatever the backlog could be, might my lord know the reasons leading to that backlog?
Yes. One is incapacity. One of the biggest issues we have in the Supreme Court is incapacity. There are 7 judges. Of these 7 judges, one is the Chief Justice, the other one is the Deputy Chief Justice. At all times, one of the judges would have to appear in the JESC, or Judicial Service Commission, as a representative of the Supreme Court. We have issues of incapacity. People, the judges, one of the judges may not be available for one or two reasons. Ailment, being away for good measure. So, one of the basic reasons why we have, this backlog is because of the issue of the quorum for the Supreme Court. The quorum is 5 judges in open matters. The quorum is 2 judges in interlocutory matters, applications. So the possibility of not having a quorum in this situation is very, very high. For example, now the Supreme Court does not have two judges, the Chief Justice and the judge of the Supreme Court. They are not available. Should anything happen to any of the other judges, it will not be possible to convene a quorum. Should, in a situation like this one, where her leadership is appearing at the JESC for this very, very important matter, the Supreme Court cannot sit, and that is the dilemma.
And therefore, my Lord, clearly you have read our strategic plan. You have seen that we have identified that as a big problem. What would your remedies be?
The suggested remedy in the strategic plan is that the Supreme Court be raised constitutionally to 9 judges. I had all my life wanted to fight that. But recently when I looked at that and the rationalization of the strategic plan for the Supreme Court, it brought me to senses. It makes a lot of sense. The situation we have now is impractical, if not impossible. It's a do or die situation. This is a very, very, very sensible, proposal that the Supreme Court firstly be improved by 2 other members or 2 other judges, and maybe in the future we can even move up to 11, depending on the constituency.
Thank you, my Lord. One of the objectives for the court is to provide authoritative and impartial interpretation of the Constitution. You have also, my Lord, heard, and please tell us where you heard it, this statement, constitutions without constitutionalism. With that in mind, would my Lord debate the particular objective of the court that I have just stated, my Lord?
Thank you. Constitutions without constitutionalism is the catchphrase emanating from a write-up by my good friend and teacher, Professor H.W.O. Okoth Ogendo, late of Njagi, most likely Kisumu County. He wrote this material a while ago, and everybody who imagines that he wants to be a constitutional lawyer or is a constitutional lawyer would have to identify with that. It's an international material. Relating this now to the Supreme Court of Kenya, which constitutionally is intended to be the master of the master interpreter of the Constitution, the impartial interpreter of the Constitution, the impartial practicator of the Constitution, in the sense that this interpretation must also be brought out in terms of must be practical. Impartial, we are not even beginning, but it must be impractical. It must be practical. The Supreme Court has done very, very, very well on this. It has brought itself out on so many aspects of our Constitution in terms of opinions, in terms of case law, in terms of advisory opinions, case law, and so far we would not want to complain. Well, there may be issues which we may further have to debate, like the position of the Constitution, the position of the Supreme Court insofar as election petitions is concerned. But you look at that jurisprudence, it is apt, it is to the point. What we may require in the future is now compare notes with the outside world and see whether we can come in and bring out the small issues and come out clean. So far, so good for the Supreme Court.
Thank you, my Lord. I do not remember what my Lord said about the issue of writing joint or individual judgments in the court at your last interview. Maybe you could remind me if it was asked of you, and if it wasn't, could my Lord please tell us what your position would be on writing individual and or composite judgments?
Thank you, good Commissioner. This was not raised with me last time. I cannot remember. 9 days ago it was not raised with me. But my answer to this would be, I have looked at the decisions of the Supreme Court in both the majority decisions and the dissenting decisions in one or two cases. I have also read the concurring decisions of the Supreme Court. In the matter for Munya, the Chief Justice wrote a concurring decision. And in that concurring decision, he made a very, very sensible argument, jurisprudential arguments, that to the extent that the Supreme Court of Kenya is not the resolution insofar as election matters are concerned. These matters come when, in the last minute, as a last resort. Before that, we've passed such a long process. Firstly, starting with the people of Kenya. And the people of Kenya must be warned that it is their responsibility to make elections work effectively. The IEBC and other institutions of government which are charged with the responsibility of dealing with effective elections.
My Lord, let me redirect you to what we are looking for today.
Please do.
Thank you, my brother. First, it is individual versus the common judgment. That's the issue today. And I wanted you, I'm asking on behalf of the rest of us, to tell us which you favor so that I could ask the final question on the topic.
Yes, I favor a situation where every judge does their judgment.
Why, my Lord?
That enriches our respective thinkings, and we are open to society. We are accountable in the sense that this is an intellectual court. I mean, we all come out with our respective thinkings, and if society finds that society will find a way of merging it. The academia and everybody out there will find a way of merging it. But from the onset, let us all come out, because we are gifted in different manners. We have our riches. We have riches which every other person do not reach, and these are personalized. Therefore, the necessity to write individual judgments.
My Lord, it is true. I agree with you that we are gifted differently. We all have our different ways of writing. We could be saying the same thing, but one of us would say it more elegantly than another one would. etc. Does my Lord have any idea at all of a situation or situations when individual judgments would not be advisable.
I have not thought about that one, but I'm imagining that there may be areas like opinions, when the court is delivering its opinions on advisory opinions. This is an issue which is contemporary. This is an issue which is governmental, and this is an issue where the court should come out in unison and say, this is what we think, this is what we sell to Kenya, this is what we offer you as a court. In that kind of circumstances, a good commissioner. The issue of individual may not work very well.
Thank you, my lord. Maybe we should discuss it at the next colloquium.
Please.
Because there must be instances where I imagine the court may want comfort in numbers. I can think of 3 instantly, but we will discuss that as the entire judiciary at a later date. My lord, I wish you well.
Thank you.
Your Honor, now I would request the Honorable Judge Wasame to ask his questions.
Judge, I wish you well. I have no questions for you.
No. You must ask 1 or 2, please. You and me, I mean, make this place happy. Why would you want to back out?
I think we respect Judge Wasame's position, and I'll now move to Judge Majaja.
Please.
Thank you, Chair, my lord. Like the court you sit in, one of the problems we have in adjudication is the problem of interlocutory applications. You agree with that?
No doubt.
Yes. Now, can you tell us briefly what are the kind of interlocutory applications that are provided for under the Supreme Court Act or rules or under the Constitution, the types of interlocutory applications?
Oh, in the Supreme Court, we'll have interlocutory applications which touch on a stay of execution. We'll also have interlocutory applications which touch on matters jurisdiction or lack of it. We'll have interlocutory applications which would come into the issue of Article 163(4), the issue of confirmation as to whether a matter is of general public importance or not. At that level, we would have interlocutory applications coming to court. The other area is the efficacy of 164(6), the issue of advisory opinions. Whether or not this falls into that category becomes an issue, and it would arise at that level.
And what of those interlocutory applications, maybe you would tell us which type does the court of the Supreme Court and Court of Appeal have concurrent jurisdiction? Concurrent jurisdiction of the Supreme Court, Court of Appeal and Supreme Court.
One is a stay of execution. The other one is on a confirmation or otherwise on whether a matter is of general public importance. In those two, we would have that kind of a situation where the two courts get involved.
And for a certification application, is it necessary to have a decision of the Court of Appeal in the first instance, or you can go straight to the Supreme Court?
For certification, it is twofold. Certification would arise from the Court of Appeal, and if the Supreme Court feels that they would want to deal with it, they can deal with it on their own, either approve of it or disapprove of it. But again, you can go to the Supreme Court on first instance.
And lastly, on the issue of jurisdiction, under what circumstances would the court or Supreme Court entertain a third appeal? You understand what I mean by a third appeal? An appeal from a decision of the Magistrates Court.
That would be under very, very extraneous circumstances. And the jurisprudence of the Supreme Court is that if this has to arise, then this matter must have been litigated from day one, from the Magistrates Court to the High Court, to the Court of Appeal, and to the Supreme Court. That is the only circumstance where this would arise.
It would have been but all matters are litigated from the Magistrates Court. What makes it different, or what is the difference between that third appeal that would have been entertained and the one the court would say there is no jurisdiction? What is the difference, if there is? I'm not saying there is, but if there is.
So my understanding of this stratum is that we would move from the Magistrates Court to the Supreme Court in very exceptional circumstances.
Okay, and tell us those exceptional circumstances. Those are the ones we want to know.
Circumstances where there is a disagreement at the Court of Appeal, at the Magistrates Court, and this matter goes to the High Court. The parties again do not feel like they have had their share at the High Court, and they go to the Court of Appeal, all the way to the Supreme Court. And this again must come under the criteria of interpretation of the Constitution. It's interpretation of the Constitution, and the other aspect of the practice of the Constitution.
Okay.
Under those two sets or terms, this would arise. If any matter comes from down there all the way to this on those two parameters, it would be a feasible matter for the Supreme Court.
So in election petitions concerning the county assemblies, can you tell us what the jurisprudence has been in relation to jurisdiction of the Supreme Court?
The jurisprudence has been that, firstly, the effectual jurisprudence of the Supreme Court in terms of in relation to its jurisprudence is that all these courts are competent and able to deal with the matters constitutional. So you cannot use that as a competence and ability as an excuse to go to the Supreme Court. So in the instant case, the Supreme Court has put it that matters which come from the Magistrates Court concerning the county assemblies must end at the High Court. Okay. That is our current jurisprudence.
Okay.
So, and
I'll leave it at that. Let's move to another area of law, which again is very important in the Supreme Court. One of the principles of devolution is that county governments shall have a reliable source of revenue to enable them govern and deliver services effectively. That one we agree. It's one of the principles.
Yes.
So how has the Supreme Court contributed to development of this principle, and probably will share with us one or two cases?
One, there was the advisory opinion on this subject, on the issue of revenue, where there was a stalemate between the National Assembly and the Senate on revenue allocation. The Supreme Court came out very, very clearly and brought out the formula or the solution to this by suggesting that they form a mediation committee, so that when we have disputes relating to revenue allocation, the committee, which comprises of members of the Senate and members of the National Assembly, will be able to thrash this out and come up with an amicable solution to the issue, or outright solution to the issue. That is my understanding of the whole thing.
And what did the Supreme Court talk about the Commission on Revenue Allocation? What did it say about that Commission on Revenue Allocation in that particular advisory opinion, if it said anything?
The Supreme Court gave it supremacy over revenue allocation, but pegged that to sensibility and reasonableness, so that in the exercise of the powers of the Commission for Revenue Allocation, they would have to do it constitutionally. They would have to do it in accordance with the law.
So that is the decision of the Commission on Revenue Allocation binding or advisory?
The decision on the Commission on Revenue Allocation is binding, but can be challenged.
Okay. And finally, you are aware of the African Charter on Human and People's Rights?
Yes, I am.
And it is binding in Kenya?
It is.
Okay. You have been in the ELRC. What labor rights does the Charter protect? Maybe you can give us an exposition very briefly in terms of the labor rights under that Charter, because they are binding in Kenya.
The labor rights which are encompassed in the Charter are the right to work, the right to dignity at the workplace, the right to, pay for labor, the exchange between labor and capital. Basically, the Charter gives what would even say is also, envisaged in Article 41 of the Constitution. Article 41 of the Constitution, and all the labor laws in this country, the Employment Act, and the other operationalizing labor laws of this country.
And are there any decisions of the Africa Commission that are relevant, or any instruments that are relevant under this treaty in explaining or expanding the right to work that you are aware of?
I am not aware of any.
Okay. Thank you very much, and thank you, Chair.
Thank you.
Thank you very much, Honorable Judge Majaja. Now I request Commissioner Marete D to ask his questions. Commissioner.
Okay, thank you. Now, I only have two questions for you, my Lord. The first one, if you go to the Supreme Court, if you look at even the way the Act that governs the Supreme Court is designed, there is the order of seniority in terms of the appointment. Now, so effectively it will be judge number 7, the effect of which is that will be expected to do a little bit more than the others, even in terms of developing judgments where there's consensus, drafts, and all that. Now, when I look at your experience as a judge for the last now 9 years, you've mainly been involved in, employment and labor relations matters, so to speak. Now, Supreme Court, of course, has, the kind of matters that you deal with go beyond what you've been dealing with in the last 9 years. Not to underestimate what you've been undertaking, but just to recognize the wide purview of what you have to deal with in the Supreme Court and the attendant learning curve. Now, coming to the question, do you think that that would be a challenge in itself in terms of, hitting the ground running as soon as you are appointed, if we were to appoint you, considering your experience which has mainly been in one particular field of law?
Thank you for that question. We must appreciate that it will be limiting, in the sense that for the last 13 to 9 years we've been in practice for in one single line, and that has permeated the last 17 years of my practice. I caught up with the labor at the Teacher Service Commission in 2003. To answer you is that we have our broadness and our personal abilities. Limiting as it may be, we are able to push in and do the learning. These interviews were declared about, we were shortlisted about 2 months ago or so. Before that, I mean, the Supreme Court was a stranger to us. We did not require any jurisprudence on the Supreme Court. As we speak now, I can bet that we are 60% through. That is why we are able to sit here and prove our case. So this becomes a learning process, and we have not been disapproved in terms of energy. We have not been disapproved in terms of ability to enter and take charge. It is not a big issue as such. We shall just get in, appreciate our position, take charge, and move on through education, through exposing ourselves, through consultation. But admittedly, that kind of practice where you've been in one line or one focus line and earlier on in another, I mean, that is a family law and succession earlier on, and now labor law can be limiting. That's a very precise and honest answer. But we can beat that outrightly because of our very nature, aggression and speed.
Okay. Now, my Lord, the second and final question. You know, I'm just thinking, as a commissioner, we've just appointed your sister as a Chief Justice from across the hill, you know. Probably if you threw a stone, probably it would reach the homestay, I don't know, because I don't live there. Now I'm just wondering, because you know, judges are wise men, in fact they are wiser than us as a commissioner. You know, the public, when they sit before a judge, they know a judge is a very wise person. Now put yourself in our shoes as commissioners. You're a brilliant judge, there's no doubt. You're answering questions well and all that, and you're competent by all means. But considering the realities that you have to deal with also as a commission, envisage a situation whereby tomorrow we say it's you, after we've just appointed your sister. How would you deal with that if you're in our shoes as a commissioner?
Thank you so much for that brilliant question. I expected that today, and if it skipped, I would have been very, very surprised. Let me give you my political theory on ethnicity. I don't use the other word. The word of TRIBE, I don't pronounce it because I think it is not realistic. It is just a figment of our poor relations. One, ethnicity has never been an issue, and I will demonstrate this. I went to Alliance High School in 1974. All other factors were constant. We would have jibes against A, B, C, and D and E, and that was that. We left the place, no issues, no injuries, no nothing. In my time at the University of Nairobi, I mean, all other factors were constant. The only requisition for a student of the University of Nairobi was just reading and reading only. I'm even surprised that we did so poorly because we didn't have any other business apart from reading. Food was available, halls of residence were available. If they were not available, we were taken to the hotels and we were given. All other factors were constant. No issues of ethnicity. To me, and having in mind that ethnicity has even become a discipline of study, my position has always been that it is not realistic. It's a creature of our own imagination, it's a creature of our own poor governance systems, and it is something we should be able to thrash out. People like you and me, I mean, who are in this country and have the wherewithal to thrash out these things, should sit and make a decision on this. It is not real. a good general walks to the battle with the best that he can at the forefront. This idea about, diversity and what have you for Kenya, maybe for now, yes, because of our perverted governance systems in the past. We may have to deal with that one. But for the future, let us sharply rise up and think out of this, because it is not real. Such that good enough, you have my sister as the Chief Justice of the Republic of Kenya, and on the other age. If we use theory number one, I may not be eligible. I may not be the best of material. Everybody may make a lot of noise about it, and I would justify them. We know where we are coming from. But using theory number two, it would not make sense. The Supreme Court should have the creme du creme of this society. I belong there. So what, barring one or two other issues, what we should have in this sense is bringing out our best generals to the war front and leading into battle, and we will sing into victory. To clarify or to polish my answer, that may be a big issue, and a big issue which I...
Judgments.
Yes, I did.
For the Supreme Court. Would you please tell us, have you identified any area or areas where you may give direction and leadership in terms of jurisprudence and its development if you were appointed as a Supreme Court judge?
I am a constitutional lawyer. That is an area I have studied and written on. It's an area which, is upmost in my interest. I may shyly also say that I'm an authority on the subject. It's my area of specialization. On this, I would offer leadership.
How have you demonstrated your expertise, my lord?
One, at the University of Nairobi in 2005 and 2006, when we went for our upper law degree. I specialized in constitutional law and government. It did not essentially carry that name, but that was my area of study, where we did matters touching on the Constitution itself, constitutional comparative constitutional law, and other matters on democracy and the legal process, that kind of thing. In my write-up for my LLM thesis, titled Towards a New Constitutional Dispensation in Kenya, the Politics of the Constitution and the Constitution-Making Process, I tackled that subject very, very effectively under Professor H.W.O. Okoth-Ogendo, and it's called the topmost mark. I thank God for that, which is a demonstration that governance has always been my issue. I have vied for NIFI. I have vied to come to this commission because of my IQ and sensibilities insofar as governance is concerned. We are saying that this is our area, and we own it cumulatively with everybody else who is in that discipline, and we can make a contribution in that line. I have also practiced in other areas, family law and succession, labor. We are able. Thank you.
Since your LLM and your political aspirations, have you at all demonstrated your expertise and legal scholarship in this area?
I have not had any further write-ups. I have pursued my career as it tilts.
Thank you, my lord. Let's move on to another aspect. As a judge of the Supreme Court, you would be asked to nominate or participate in the nomination of one of your colleagues, and you yourself would be eligible to become the representative of that court to the Judicial Service Commission, correct? Correct, my lord?
Yes, sir.
What attributes would you look for in the person to represent the court to the Judicial Service Commission?
One, ability. Firstly, let me say that at that level, any judge of the Supreme Court is capable and competent of appearing before, representing the court in this commission. But specifically, if that was very, very necessary that we nominate one and get him to the Supreme Court, we would look for ability and agility, flexibility, the team power in the candidates, issues on HR, because HR comprises a very, very critical part of the functions of the Judicial Service Commission. So we'll be looking for a leader who is all round, a leader who is able, not one among his equals, but one who would be able to do it better than any of the other 6 members of the Supreme Court.
And where would collegiality play a role in your determination of who to send?
That is where I started. I said that from day one, it could also, and this is a problem we also have in our small court, the Employment and Labor Relations Court. We are 12. We've gone to elections twice, which would be easier in the circumstances, unless a member of the court opts out and says that I'm not interested, like I have insofar as my court is concerned. I've always said that I don't want to be principal judge. Let it go to anybody else, but not myself. On the same footing, we could have a rota, seniority or juniority, whichever is earlier, so that everybody is able to, because competencies, abilities. So the other issue is choice. Do I want to be there or don't I want to be there? So that in that rota, everybody takes their fair share. When the time reaches, you just get there automatically. We don't have to go to elections. Elections, we know them. In this country, where do they take us? I remember I got 3 votes when I applied to join this commission. 3 out of 4 or 2. That is what elections are.
Thank you. Sorry,
do I do the finesse of my answer? Collegiality would also come in several senses of the word. Assuming my approach, my formulas, my everything doesn't work, would have to sit as a court and agree that this is a big issue, yes, representation in the Judicial Service Commission, yes, but it's not a matter of life or death. So how do we go about getting one of us to be a member of, to represent us at the Judicial Service Commission? And through, involvement, through consensus, in a very friendly manner, get one of us to come to the Supreme Court, to come to the JESC, because any other method can bring a friction. And you remember, we are only 7 or at the best 9 in the future, and that can be extremely dangerous. So collegiality is utmost. It is a primary. It is cardinal. It is very, very important. We must move around with each other, cajole each other, buy each other tea if we can, or any other drinks, weird or not weird, and come to a conclusion, to a consensus as to whom we take to the Judicial Service Commission.
Thank you very much, my lord, for answering those questions.
Please, thank you. It's been a pleasure.
Honourable Chair, nothing else from me. Thank you.
Thank you very much, Honorable AG. It's now the time for Commissioner Njagi to ask his questions.
Thank you, Chair. Judge, good afternoon.
Good afternoon, sir.
I want us to look at another angle. In this case, I want you to focus to you as a state officer, because as a judge of Supreme Court, you are also a state officer, and you are bound by Article 10 of the Constitution. When you look at Article 10 of the Constitution, as a state officer, one of the principles of governance, one of the principles and the values of governance is sustainable development. Sustainable development. What is the role of judiciary in your view in enhancing this principle of governance under Article 10?
Thank you. Many of us in the judiciary, and particularly judicial officers, mistakenly believe that we sit here to write judgments, and you carry your files and do blah blah, and in that imagination forget that you're in governance, and at the center of it. Our decisions are determinants to governance patterns in this country. You're either directing this way or the other. This is the way we ought to go, this is the way we ought not to go. And that way, we are in the center of governance. And we are in control of the governance patterns of this country. That is why we are an arm of government, like the other two. So in this regard, judges should always have appreciate their positions as a transformative leaders.
Appreciate that is one. Two.
Number two, you must make decisions which are pro-development and pro-Kenya. You're not going to allow situations that you are making decisions that stumble Kenya, unless that is really the spirit of the law, which would never be. No law would come out with a situation that stumbles us in our development patterns.
Okay, from that basis, Honorable Judge,
please,
I want you to look at our medium-term programs, MTF, and I want to look at the 4 key agendas that the government is in the process of implementing in the country as we sit here this afternoon. Would you share with the Commission those 4 programs of agendas as we know it, the government is currently undertaking? 4 agendas. Key agendas.
One is provision of housing. The other one is medical services to the Kenyan citizenry. The next one would be sustenance of a rule of law kind of a situation where we are able to run ourselves, our governance patterns in appropriate manners in accordance with the Constitution and the laws of this land. And what is the last one? It is evading me. Given a little more time, which time we don't have, I'll be able to pick it.
Okay.
But the politician is me, is failing me.
Okay.
Thank you.
Let's move on, Honorable Judge. And I want us to look at the public finance. And there's a judge of the Supreme Court. Definitely you'll be having some resources with you. And I've also seen that some of your duties in your current station is your managing staff and also doing work on administration. Under the Article 2, Chapter 12 of the Constitution, there are 4 key general principles on management of